Welcome, everyone, and thank you for joining us for today's webinar, the Clery Act and Title IX, Practical Considerations for Coordination and Integration. This webinar is one of a series of free webinars available for National Campus Safety Awareness Month. I am Alison, the Executive Director of the Clery Center, and joining me today is Gina Maisto Smith and Leslie Gomez, both partners at Pepper Hamilton. And they will introduce themselves in a little bit, but I am really thrilled to have them here with us today. I think they are often flying all over the country and working with colleges and universities to demystify some of the challenges in implementing Title IX and the overlap of Title IX and Clery. So we're really excited to have them here with us today. We also have my colleague Megan, who will be the producer for today's webinar, and she will work with you if you have any tech-related issues throughout the session. I'm going to go through a few housekeeping items before we get started. We encourage you to interact with us throughout this webinar by typing. We make a point throughout the webinar to allow time for questions and feedback, so you can type any of those types of comments or questions using the Questions tab. Please keep in mind that we do have a few hundred people with us today, so we will try our best to address as many questions as possible. We will also record today's webinar, and it will be provided to you in tomorrow's National Campus Safety Awareness Month email, as well as it will be available for free on our YouTube channel, the Clery Center YouTube channel, which has a number of webinars available to you. Before we move into additional content, we just want to share a little bit more about our work here at the Clery Center. For the past few years, the Clery Center has used National Campus Safety Awareness Month as an opportunity to provide professional development and programs and resources to colleges and universities. Through this month, we make sure that we provide all of that information available to you in email updates, as well as on our National Campus Safety Awareness Month page on our website. If you had not yet had the opportunity to sign up to participate in the year's campaign, you still can do so by clicking the link in the control panel. Thank you again to all of you for joining us today. In your control panel, you'll also see an evaluation link of today's webinar. At the end, we really would appreciate it if you would take some time to give us your thoughts and feedback. As you know, it takes a lot of time to put together high-quality content, and we really would love to see the feedback that you all have and any thoughts that you have for next year. A little bit about the Clery Center. Our goal is to work together with colleges and universities for safer campuses. We talk quite a bit about how we do this by leading with mind and heart. It's one of my favorite statements that we use because we don't not only think about the technical elements of the law through some of our work with the Office on Violence Against Women, with the Campus Program Grant and technical assistance in our training programs, but we also see Jeannie Clery's picture every day when we walk up our steps. So everything that we do is really rooted in heart and transparency and collaboration. We also really rely on partnerships, and that's one of the reasons why we're here with Gina and Leslie. We have many partners in this field, and we really believe that we have to do all of this together. And lastly, I just want to stress again, the evaluation that we have at the end, everything that we do at the Clery Center is data-driven, so we really rely on feedback and data that we collect out from institutions to inform the work that we're doing. Some of the programs that we have a membership program where we work with colleges and universities throughout the year on training and education. It includes self-assessment, technical assistance, annual security report reviews, National Campus Safety Awareness Month, again, every September, to provide free training and technical assistance. We do a lot of policy work with folks on Capitol Hill, national and state level, and then our Clery Act training seminars, both in person and online. So I'm going to pass it over to my colleagues, Gina and Leslie, to provide a little background on themselves and frame our conversation for today.
Good morning. This is Gina Smith, and I'm here with my colleague, Leslie Gomez. Good morning, or afternoon. We're so happy to be here with Alison, and I loved your introduction, Alison, about the mind and heart, because our work and the manner in which we do our work frames things in a similar way. We often look to the mind, body, and spirit of these issues. We like to think of it as owning the mind of it, the regulatory framework and the law, the body of it, the dynamics and how these things affect those we are serving, and the spirit of it, how each campus can integrate those things in their campus communities based on their resources, history, culture, and personnel. So we often say we look to these compliance issues through the lens of compassion, and if we're compassionate first, we will necessarily comply.
Gina and I are both former public servants in terms of our prosecutor role at the DA's office for 15 and 20 years, and in the work that we do, we are humbled to continue to think of ourselves as public servants with the ability to reach and work with colleges and universities across the country. We have a strong focus on policy and procedures, on building infrastructure that allows the school to coordinate and integrate all of our federal and state legal obligations in a way that balances trauma-informed practices that reduce barriers to reporting and participation while still operating within fair and impartial process. We are delighted to participate in this webinar with Alison today because it really speaks to the coordination of CLERY as amended by VAWA and Title IX and the way that we as institutions need to coordinate our responses so that what we're providing to our students are seamless in a way that perhaps the federal framework has not laid out as neatly as we would hope.
I'd like to start first with framing the conversation at a high level. As we all strive to compassionately integrate trauma-informed, fair processes for all, and those processes that will lead to reliable outcomes, I'd like to frame our thinking with these 4 practical concepts. First and foremost, when it comes to any student, faculty member, staff member that comes before us with these issues of Title IX and CLERY, VAWA concerning events, we have to start with thinking we don't know what we don't know about an individual's experience, that we need to take the time to understand that and recognize that each individual's experience is unique. In doing that, we need to flip the lens and look at those we are serving, not ourselves and our own responsibilities, but those we are serving, which is our primary responsibility. To do that well, we need to often embrace the tension of understanding the law and integrating the law and communicating the law in a seamless and understandable way, but we need to embrace the tension of the law, the dynamics, and our policies and procedures, and remember that the most successful response is a response that coordinates our teams across campus constituencies. The multidisciplinary team approach is going to be described by Leslie in a later section today. So starting off first with the skeleton of this, or an outline of the federal regulatory framework, there are 2 major laws, and I say 2 major laws because there are others that inform our practices and processes, but the major ones that we're going to talk about today are Title IX and CLERY. And as everyone, I'm sure, on this webinar knows, Title IX prohibits sex discrimination in educational institutions that receive federal funds. CLERY, as most of you know, covers timely warnings, requires reporting of crimes based on CLERY geography, and also requires education prevention programs and policies and procedures, and was recently amended in 2013, implementable in 2014, and after the negotiated rules in July of 2015, the Violence Against Women Act, as it amended CLERY, expanded the CLERY reporting requirements to include dating violence, domestic violence, and stalking to the already required sexual assault, but it also expanded some of the requirements around process, grievance procedures, and services. A point about the amendment to CLERY by VAWA that I'd like to focus us all on now and to keep at the forefront as we think about all of these concepts throughout today is that it applies to both students and employees. And when I say it, VAWA, as it relates to dating violence, domestic violence, stalking, and sexual assault, applies to students and employees. I want to turn now to the intersections of CLERY as amended by VAWA and Title IX and talk a little bit about the scope in the framing of definitions. In the CLERY context, the definitions are clearly outlined in the statute, but they are sexual assault, dating violence, domestic violence, and stalking. On the Title IX side of the house, there's a broader framing, including sexual discrimination, sex and gender-based harassment, and sexual violence. So it's important when we write our policies and procedures and communicate to our constituencies that we wrap our arms around including an understanding of both definitions, particularly because there's overlap, but it is not precise overlap, and sometimes it intersects in some places and doesn't in others. The other area in the scope section that I'd like to highlight is that there are also other Clery crimes, a list of which we're not going to talk about today, but those crimes, in addition to the 4, sexual assault, dating violence, domestic violence, and stalking, are reportable as related to Clery geography. And the Title IX side of the house, the jurisdiction as to how we are to respond, is related to incidents that occur on campus in the context of any school program or activity that could be on campus or off campus, and those events that occur off campus and not in the context of any program or activity, but would have continuing effects or impacts to an individual on campus. The way we look at the continuing effects on campus is through the lens of how it impacts an individual that has been impacted by sexual harassment or sexual violence. Further, we need to apply Title IX as we do to other types of misconduct. So for example, if in your student conduct code we say that we are going to look to events that occur outside of the jurisdiction of our institution, and we give ourselves jurisdiction to take action on something that may happen in the hometown of one of our students, so too must we apply that approach to incidents that are covered by Title IX. The last section, that's a framing section to begin, is another intersection spotlight. And I want to spotlight, one, that the definitions, while they may be overlapping, are not necessarily consistent and perfectly aligned. The procedural requirements as well differ slightly. For example, in Title IX, under Title IX, we are told that the burden of proof that we must use is preponderance of the evidence. If we flip our lens to what Clery says about the burden of proof, all it says is we must state what standard of proof we use in our policies and procedures. There are written notice of rights, which would be included in our approach in Title IX, but is very specific in the VAWA requirements that the notice of rights and options needs to be written. 3 other areas that schools are wrangling with as we move across the country and watch the development of policy and procedure are the areas of advisor of choice, equal and timely access for the parties to all information that will be used, and that written notice of outcome that includes a rationale and is to be given simultaneously to both parties. Those 3 areas come out of the VAWA requirements on their procedures, and those 3 areas are often an expansion of what we've done in the Title IX side, on the Title IX side of the house, particularly when it comes to employee processes. And so these are things that we want to pay attention to when we are coordinating our policies and practices in the Title IX space, and we are incorporating our communications and materials to all of our constituencies in the implementation of these compliance requirements. And remembering first that if we are compassionate and care about what our constituencies need, we will necessarily comply.
And so we're going to start by, the way that we frame this conversation is to talk about the top 5 kind of themes that we're seeing when we talk about Clery and Title IX. We can certainly spend days training on both of these topics. But how we pulled this together was to really compile what we're seeing in the field and to address some of those key challenges. So I am going to pitch it to Leslie to start talking about reporting.
Thank you. And as I dive into reporting, I wanted to first respond to a question that appeared. The question was, can a college deem a sexual assault claim to be retaliatory and refuse to investigate it? And the simple answer to that question is, under Title IX, if we knew or should have known of an incident of sexual harassment, or in this case, sexual assault, we have an obligation to investigate or otherwise determine what occurred. So I don't think prior to running the investigation fully to ground, we can make a decision that it's retaliatory, we always have to investigate fully, evaluate, and make that decision. We certainly see cross-complaints that arise within the context of a dating violence, domestic violence, or sexual assault. The mere fact that the cross-complaint comes from a respondent does not mean that we ignore that. We always have to accept and embrace the Title IX obligation to investigate that report. The second part of that question was if the college does not investigate it, that they would not report it in their CLERY data. And to be very clear, the CLERY requirement for including a report in our annual security report, in our daily crime log, is tied to the report itself, not to whether or not it is ultimately substantiated by investigation. So moving from that area into speaking about reporting, we do have two separate regulatory frameworks that address what our individual employees' reporting responsibilities are. On the CLERY side of the house, it's essentially those people who are responsible for campus safety, campus police, security, or escort. It's those that we tell individuals you can go to report a crime. That may be, for example, student life, it may be resident assistance, it may be other individuals that we hold out as resources to our community. And lastly, there's a catch-all category that includes officials of an institution with significant responsibility for student and campus activities. And in identifying who those individuals are, it's important that we look beyond a job title, but to dive deeply into understanding the role and the function that the individual serves. It's been our experience as we move across the country that in this space, many campuses are still struggling with how to adequately identify, define, and notify who their CSAs are. And when we ask the question in audiences at large trainings, we often have confusion from individuals who aren't sure whether this fits them or not. Setting aside the CLERY side of the house, would like to turn to the Title IX responsible employee analysis. And under that analysis on the responsible employee, it's any employee who has the authority to take action to redress or respond to the harassment, anyone who has the duty to report to appropriate school officials harassment or other forms of misconduct, and then anyone a student could reasonably believe has this duty or authority. OCR gives us some guidance as to what that may look like in their questions and answers on Title IX and sexual violence, which were included as one of your resource documents. They say very clearly, for example, that in their analysis, a resident advisor or resident assistant would fall within that analysis. They have not squarely addressed in writing whether or not a faculty member would fall within their analysis. Many schools are making the determination that they do because the view from a reasonable student's perspective is that an individual could reasonably believe that a faculty member has that authority or responsibility. Looking at the graphic that you have in front of you, one of the things that's become eminently clear as you overlay these statutes one against the other is that if we look at the definition of CSA with the catch-all category of officials of an institution with significant responsibility for student and campus activities, that is a circle within the Venn diagram that would fit within the Title IX responsible employee category of an individual who a student could reasonably believe has this duty, authority, or responsibility. And DOE, in speaking about this issue publicly, has shared their view that CSAs would necessarily also be responsible employees. There may be other reporting obligations that your institution holds within particular job descriptions, and many states, all higher education employees have the responsibility to report child abuse. Some have elder abuse reporting responsibilities. Within your process itself, they may have the responsibility of reporting academic integrity and other things. And many states have healthcare professionals. If we were to look at Ohio, for example, one last reporting obligation, all persons are required to report felonies. And so we need to think very carefully in a coordinated way about what an individual's reporting responsibilities are so that we can streamline this legal analysis and wrangling that happens behind the scenes, and our students and employees understand what happens when you share information with a particular individual on your campus, and our employees understand what to do with that information. One small distinction that I would like to tease out, traditionally we have looked at our CSA, or Campus Security Authority responsibilities, as the space where we can submit as an employee to our official or office designated by the institution to receive and collect crime report information in an aggregate or personally de-identified way. that we can send in information as long as it contains the nature of the crime, the date and the time it occurred, the date and the time reported, and the location. And while that is permissible under the Clery Handbook, it is our recommendation for ease of reconciliation and for the ability to ensure behind the scenes that we are coordinating with the offices that need to respond effectively. The CSA data is shared with identifiable information internally, recognizing that external reports would not include identifying information and would maintain the privacy and anonymity of those individuals involved. One of the reasons that this is so critical is that the Title IX reporting obligation, which applies to sexual and gender-based harassment and violence, is a reporting obligation that includes, in particular, the names of the reporting party, the name of the respondent, any other students involved, and any other relevant information. And so it's a very specific and particularized reporting responsibility. Both of them, it is our recommendation, should be immediate so that on the CSA side of the house we can carry out our duties with respect to a timely warning analysis and safety considerations, and on the responsible employee side of the house that we can move forward with prompt and equitable investigations as appropriate and other steps to investigate or otherwise determine what happened. Schools are really moving together to ensure that they are responding in an integrated way to each of these requirements. Inclusion of the data in our external productions, ASRs, once a year, inclusion of it in our daily crime log within 48 hours, the timely warnings, which Alison is going to talk about in just a few moments, and then thinking about under VAWA and under Title IX, the need to give information to a complainant, the need to provide interim measures, and the need to take the steps that I've just outlined. Some proactive and productive, effective practices that we've seen across the country are, with great clarity, identifying who our CSAs and responsible employees are, setting clear expectations for reporting with respect to both content and timing of reporting, provided integrating training. In higher ed, many of us are being asked to do far more with far less on a daily basis. We have limited face time and limited resources. To the extent that we can provide a training to our employees that clearly sets forward their responsibilities, to the extent that we can provide information to our students that gives great clarity about how information will be used when it's shared, that will inure to the benefit and the ease of simplifying access to our process. And finally, we need to ensure that our individual employees, our CSAs in particular, have the information that they need to be able to do their job well, and that means to identify what they need to report, where they need to report it. We'll come back and talk about multidisciplinary teams and the importance and how you can streamline response to this information in a coordinated way.
And so something we want to touch on here is talking about timely warnings and emergency notifications. Timely warnings have been a part of the Clery Act since it was passed in 1990. Emergency notification was added to the Clery Act in 2008, so it's important to make a distinction between the two. Timely warnings are a narrower focus. Timely warnings are focused on reported crimes, Clery Act crimes, which can certainly include dating violence, domestic violence, stalking, sexual assault. Emergency notifications have a broader focus. So emergency notifications can be weather-related. They can be a neurovirus outbreak on campus, a spill in your chemical lab. Timely warnings are specific to Clery Act geography, so it has to be in those on-campus, non-campus public property locations, while emergency notification can span kind of a broader space on or beyond campus. Timely warnings have to reach your entire campus community, so when you put out the notice, it has to be through a vehicle where it has the ability to reach your entire community, whereas emergency notifications can be segmented. So if you have a spill in your chem lab, you can segment that to your science buildings or that particular section of your campus. With both, there is some discretion in issuance. With timely warnings, the language in the law talks about issuing the warning as soon as pertinent info is available, whereas emergency notification says issue immediately upon confirmation. So you really want to weigh and think when you're putting together your policies around these in Clery about how you're making the determination. You want to make sure that when you're getting it out, you're considering things like, are students tweeting information out? Are you up against what's going out? Who's putting the facts out? We're really covering timely warnings on a high level just because timely warnings in particular particularly intersect or can become challenging on campuses around sexual assaults. And I know we've already had a couple of questions come in around issuing a timely warning for every sexual assault. And so one of the myths that we put up here is that you must issue a timely warning for every sexual assault. The fact is, you have to evaluate every sexual assault. So any report of a Clery crime, and in particular here we'll talk about sexual assault, you have to evaluate the risk. And you want to look at, is there a current or ongoing threat to your campus community? And it has become, timely warnings on college and university campuses have become a topic that the community, your local paper, may be concerned about. You may get questions from faculty saying, we heard there was a sexual assault, why were we not warned? So you have to be empowered to take these on a case-by-case basis, determine if a warning goes out. If a warning does not go out, you're going to document that. And if a warning does go out, you want to make sure you're not putting anything that could identify that victim, because that can have a chilling effect as well on your campus. So there are a number of different levels you want to consider. That goes hand in hand with the next myth. You have to include the exact location of the assault in the warning. Again, you have to evaluate on a case-by-case basis, putting that location in there. Could putting that location in the warning possibly identify the victim? So for an example, if a campus has one residence hall and you identify that it happened on the 3rd floor of that residence hall and the student moves out the next day, does that put the campus at risk of identifying who that student is? You must include the details of the case and referral to law enforcement in the timely warning. We have worked with campuses where their timely warning will include such specifics as the student decided not to go forward with a conduct process, or the student decided not to report to law enforcement. That is not information that your community needs to know to prevent an current or ongoing threat or to protect themselves. That, quite honestly, is something that could potentially identify the victim. So you really want to think about how much information you're putting in these timely warnings, what is needed. The last myth that we have on here is you do not need to include consultations in your policy. And that really puts you at a risk of noncompliance. We have worked with many campuses. When we look at their timely warning policy, it will say that the policy or the decision to issue a warning falls on 3 people, and typically they're within public safety and campus law enforcement. The challenge is when we go a step further and we actually talk about the process, we'll learn things like the president's office needs to be called if it's a sexual assault, or we have to call marketing and communications because, you know, the White House is considering or talking about sexual assault. So we are really concerned with what kind of communications we're putting out. If you have a consultation process like that, there's 2 things you want to think about. One, you have to document you have that process and make sure that's in your policy. But then the second part of that is, does that process make sense? Is that going to hold up potentially notifying your community? And are there ways to talk about, I think one of the biggest challenges we see around timely warnings is we're not seeing experts on campus empowered to make those determinations. If other places come into play here, communications, marketing, the president's office, it can really slow down the process. Could they be involved in a conversation beforehand? Absolutely, and that's something you can think about doing. We list here the Title IX risk factors because a lot of times when we talk about sexual assault in particular and issuing timely warnings, these are some things you can consider in terms of if there's a potential threat to the community. So if you get a report, for example, and the victim who is reporting says, you know, the perpetrator had a weapon, he threatened to use it, he keeps it in his residence hall, that's something you want to consider that could be a potential risk or could be a threat. Some things you want to consider for recommended practices. You want to make sure that you have a clear policy, a clear protocol to go through when you're talking about timely warnings. You also want to make sure you're identifying who the decision makers are, who's making this decision on a case-by-case basis. Documentation is the key piece. So if you have someone come in from Department of Education and do an investigation for Clery on your campus, they may see you have 3 reported sexual assaults and ask where those timely warnings are. You can then say and go and say, we issued 2 timely warnings and here they are, and for this one case we didn't issue a timely warning, and you're going to want to point to documentation really determining why you didn't issue a timely warning. You want to consider a multidisciplinary team, maybe not in every decision, but when you're thinking about your process, how you're communicating with your students. Something that we've heard a lot from student activists throughout the country is that timely warnings can have a chilling effect. So you want to make sure that in those warnings you're encouraging students to come forward, encouraging students to get help, communicating where they can go. And we're going to move right into confidentiality here to talk a little bit about confidentiality, the distinction between confidentiality and privacy. Because a lot of times when we're talking about sexual assault on college and university campuses, there's a difference between students reporting and a student wanting to tell someone in a confidential way and not really sure. They're just trying to get a sense of their options. We know that there can be inconsistent language between federal and state laws, and we'll address that a little bit later on in this section. We know that there are students and employees on our campuses who would like to obtain confidential assistance, and they can do so. They have people that they can talk to on their campus who are mandated to keep information confidential. We know generally on campus we're talking about medical providers, clergy who are acting in a pastoral counseling profession, crisis counselors, licensed counselors. We are going to talk a little bit about the role of victim advocates under Clery with campus security authorities. And there are certainly exceptions to confidentiality that can include mandated child abuse reporting, imminent risk to self or others, health professionals, again, on the basis of conduct. And then again, you want to be sensitive or aware of FERPA and the FERPA requirements around these issues and the intersection there. And I'm going to lead through this session, but ask Gina and Leslie to certainly chime in when they see need be to focus on the Title IX section of this. But with Clery, pastoral and professional counselors are exempt from Clery reporting. There are opportunities where there could be voluntary confidential reporting where you're asking a client if they want information included in a Clery report, and that's voluntary, but that is not mandated by Clery. It's only to determine whether or not you have it. You want to think of these people and make sure they're acting in these roles. So for example, a pastoral counselor is going to be someone who's acting in that capacity, who's a pastoral counselor acting in that capacity, who provides confidential counseling. You don't want to talk about any priest on your campus. They have to be acting in that profession. Professional counselor, which in the Clery handbook, we got a little more guidance as to what a professional counselor is, where it really kind of dictates the licensure and the certification. This is going to be someone who is working with students typically in your counseling center, counseling and psychological services. With Title IX, campus mental health counselors, pastoral counselors, social workers, psychologists, again, people with that licensure, providing any kind of mental health to your community. You want to make sure that you're really communicating on your campuses who these people are. There's a real benefit in outlining who is confidential on your campus and making sure in programs and outreach and education you're communicating who these resources are.
We really encourage schools to delineate in their policy the difference between statutorily protected confidential resources and other individuals on campus who will maintain privacy. I'd like to draw the attention to the use of the word confidentiality is used both within the VAWA amendments as well as Title IX in different ways that don't necessarily comport with that distinction. For example, one of the questions that we often hear is, what if a complainant wants to come forward and request confidentiality? That's how OCR speaks to it. A number of the questions that this group has submitted is, do we have an obligation to investigate when a complainant requests confidentiality? Essentially, under that context, and we're not going to go deeply into this for the purpose of this webinar, OCR has said that when an individual requests, and I'm going to substitute the word anonymity, that their name not be shared with the respondent or that no investigation occur, we are required as an educational institution to engage in a balancing process where we evaluate the complainant's wishes with the risk factors that were set forward on an earlier slide listed as Title IX risk factors. So essentially, we are considering and evaluating whether or not the complainant's wishes can be acceded to, or if we have a broader risk to campus safety or a broader obligation to maintain an environment free from harassment and discrimination. So as you're thinking about in policy how you write and respond to these issues, this again comes back to very clear communication to your students, to your employees about how information may be used based on where it's shared within the institution. And that brings us to the next slide that Alison is going to talk to, which is a little bit of unclarity in how the role of a victim advocate center or a women's center is being talked to and treated by both Clery and Title IX with respect to reporting obligations and how they may be held out to the community.
So the recent handbook, the 2016 Handbook for Campus Crime Reporting under the Clery Act, really broke down, went a little deeper into the obligations and the role of a campus advocate. So we know that Clery looks at exempt from reporting pastoral or professional counselors, but they actually specifically identified victim advocates or others who have a role or responsibility for providing victims with advocacy services, so going through different options, as well as members of a sexual assault response team as two people or two classifications that would be considered as campus security authorities. Part of the rationale that we understand it from the Department of Education around that is, one, that you're identifying these are places where you need to report crimes. These are people that they're identifying to whom you should report. The other being that there had been kind of a historical disparity of campuses reporting lower numbers because they weren't including information reported to places where they were identifying students or employees should go to report sexual assaults in particular. Something to keep in mind here is it does not require disclosing personally identifiable information. So again, you're just including the number, the specific information, really giving it to public safety, campus security, the person coordinating Clery to determine maybe if to count it in the statistics and then determine if a timely warning should go out to evaluate for a timely warning risk. One of the challenges that we're seeing here, and I can certainly ask my colleagues to chime in as well, but one of the challenges we're seeing here are more of organizational dynamics. We have talked to campuses where they've been doing this for years and we're always under the impression that they should do this, and they have a process within their intake where they'll talk to the student about what they need to share and that the information is still private. It will not identify them by name. It will help them to evaluate if a timely warning needs to go out. And it's been interesting to talk to students around this because some of the students who have been more forthcoming have said, you know, I actually wish my campus issued a timely warning. So I think that the assumption is always that students want that confidentiality, but again, I think that is an assumption. So really building a process where you're evaluating risk, you're evaluating safety, you're communicating with the student through the process what their rights are and what you need to share and how you can still keep it private. One of the challenges that we've seen is when there's any kind of rub, particularly between campus public safety or the Victims Advocacy Center, Women's Center, and if you have a campus public safety department saying, we have to issue a warning, and quite honestly, when you have an over-issuance of warnings around sexual assaults, then sometimes I believe from what we've seen, some of the folks in the advocacy centers feel kind of pressure and that they're not being listened to. So I think there has to be a meet in the middle type of point. I don't know, can I pitch to you all to talk a little bit about OCR under Title IX and the guidance?
Sure. So in the Q&A that came out on April 29th of 2014, OCR did create a new category of individuals that were essentially a carve-out to responsible employees but did not fit within the rubric of the confidential resource that they have always held out as a carve-out to responsible employees. And what OCR said is that schools now have the latitude to designate certain on-campus sexual assault centers, victim advocacy offices, women's centers, or health centers as non-professional counselors or advocates, and that they can be permitted to share information with the Title IX coordinator in a general way that does not include identifying information. This is a practice that some schools are choosing to put into place because they don't have access to confidential resources on their campus, or because they're seeking to reduce barriers to reporting and hoping that identifying a women's center or a victim's advocate who does not meet the state licensing requirements for confidentiality, or perhaps an LGBTQ center might be a more open place to be able to share information. If schools choose to do that, and there are reasons, of course, that schools may choose to or may choose not to. If schools choose to do that, two things are critically important. One is to ensure that we have very clearly communicated with the individuals who would be accessing this non-professional or non-pastoral counselor or advocate, that they understand that there are limits on their ability to maintain information as truly confidential, that that information is not protected by state statute, and that that information could be requested by a law enforcement agency, by court subpoena, or in civil litigation, and there is likely no protection that would prohibit that information from being released. Second, and really if we think about our Title IX obligation, if what we are seeking to do is to identify patterns or systemic problems, and I have information that's being held within my non-professional counselor or advocate space, I'm essentially delegating my Title IX responsibility to an office that may not have full access to all of the information that a Title IX office may have. And so critically important as we think about this sliding scale of balancing, offering new resources and additional places for people to get assistance, that we also think about continuing to break the culture of silence and how we build a protocol or a mechanism that says, generally speaking, this information can be shared with the Title IX coordinator in a way that is initially maintains the anonymity of the individuals, but the Title IX coordinator may need to ask for identifying information. A great place to look at how a school, I think, has really written this well is Hampshire College and their policy where they speak to private resources. It also gives a nice layout of the difference between a responsible employee and a confidential resource. And it recognizes much of what we're trying to do in this space, which is to balance competing considerations, balance victim agency and autonomy with the institutional obligation to take strong responsive action where there is a risk to campus safety or where there is a concern that we need to take more effective action to eliminate, prevent, and address the impacts of any harassment, discrimination. Again, this is a space that we're seeing a lot of conversation about across the country. It is worth taking the time with your stakeholders and constituents to unpack the conversation, to debunk some perhaps longly held positions, and to recognize the shared goals that I think all of us espouse in this area to find good collaborative working relationships.
And so the last kind of closing slide in this area is think about taking mandated reporter kind of out of your vocabulary in this section. Obviously, when we're talking about child abuse and mandated reporting, that's a proper place for it. But particularly when you're talking about to some students, for example, who are responsible employees or campus security authorities, whenever you tell them they're mandated to do something, quite honestly, if you tell me I'm mandated to do something, you know, your spine goes up a little bit and you feel like immediately saying, I don't have to do that. So I think if you're communicating, and we've done this we have a responsible employee and campus security authority training video that really goes deeper and talks to people on campuses doing these things, saying, what does this mean to you? Why is it important? And I think through this type of education, and if you have these conversations, talking to people about what the spirit of all of this is, it can be helpful. I touched on voluntary, confidential, and anonymous reporting under Clery. Anonymous reporting are obviously systems you might have in place that allows people within your community to anonymously report. These have been done through kind of Dropbox things and sometimes through online if it can be de-identified. Voluntary confidential is something, again, that you're determining, does your counseling center, for example, have a voluntary confidential reporting process, and what does that look like? And many campuses are doing that to get a more accurate number of how often this is happening. You want to make sure you're really distinguishing between reporting, if someone wants to report, and confidential resources, and really training people on what their role is. And this includes people who are going to have rapport with students, coaches, Greek life, RAs, kind of really training them on what to do if a student discloses something, because they do have obligations under both Clery and Title IX, and they're not going to be able to keep it confidential. So helping them communicate how they can keep it private. And really, no matter how wonderful your services are on your campus, I worked on a campus that had great services, but consider partnerships with external resources. So consider providing students employees options that are not on your campus, just to give kind of another source or another place where they can go and seek help.
So we want to turn to the concept of coordinating our responses and what this might look like within our infrastructure. Alison, Gina, or I have each touched on a number of the concepts here. I'm not going to dive deeply into each of these sections except to suggest that we must have a Title IX coordinator who is appropriately resourced and has authority within the institution. That Title IX coordinator must work very closely with the individual on your campus who is tasked with the CLERY coordinator responsibilities. I sometimes think we've moved to a world where we have a new VAWA coordinator that encompasses all of these roles together, and certainly we understand that at large institutions that the overwhelming responsibilities that are attributed to either a Title IX coordinator or a CLERY coordinator are something that might require 3 to 5 employees. I know that those of you who were with me by audio are probably throwing tomatoes because certainly you're trying to do, again, more with less. But recognizing that coordination is critical. We're going to talk about a multidisciplinary team and how that overlays on the concepts we've addressed, moving through to the uniform policies and procedures as we've addressed the other two directly. Gina referenced some of the distinctions between how Title IX and CLERY carve conduct and how that has impacts on procedural requirements. And so as you think about clarity to your community, having one uniform policy with consistent definitions that apply to all students and employees can be a really helpful resource to offer to your community. You can have separate procedures for students, separate procedures for staff, separate procedures for tenured faculty, as long as those procedures meet the requirements of Title IX or VAWA. And as you're thinking about those distinctions, if you choose to coordinate and collapse all of your conduct, sexual and gender-based harassment and violence, dating violence, domestic violence, and stalking under one policy, you necessarily will have been choosing to extend the VAWA procedural requirements and add them into the Title IX responses to sexual and gender-based harassment and violence. One of the questions that we received was, in a case of sexual assault, if I have a student complainant, do I have to give notice of outcome to the student about the employee sanctions? And the answer is, in a sexual assault, you must, that the notice requirement is for the outcome, the sanction, and the rationale without any limitation. If we were in the realm of a Title IX only approach where the allegation was sexual or gender-based harassment or violence, we have to give notice of the outcome, meaning the finding of responsibility or not, and we'd also have to give notice of those sanctions that directly relate to the complainant. As we move toward thinking about combining policies and procedures in a uniform way, it may mean that we adopt the CLERY VAWA requirement of all information about the notice, the sanction, and the outcome, the sanction, and the rationale. So things to think about as you're wrestling with the integration of these two federal laws. Trauma-informed investigations go without saying. Communication, we've spent some time talking about language, how we use it in a clear way. Equally important, and I know that both Gina and Alison have referenced this, is documentation of what we do, why we do it, and the factors that we relied upon in reaching our decision. Gina's going to spend some time talking with you about education and prevention before we wrap, but I wanted to give you 3 additional slides in this space. This is a graphic that I hope can help you visualize the things that we have been talking about. Before I unpack the graphic, I want to read one more question to you. If a victim who reports an incident to campus police that falls within the requirement for reporting through Title IX, and the student does not want Title IX notified of their personal information, name, does campus police have an obligation to violate that confidence and pass the name on to Title IX? This is a perfect framing question for this coordination slide. So if we unpack that question, campus police are clearly responsible employees under any definition of responsible employee. Campus police would be required to share the information with the Title IX coordinator in a manner that is consistent with state law. There are some state law provisions that speak to the confidentiality of criminal history records information and how that can be used. But bearing in mind the reference that we made earlier to the balancing of an individual's request for confidentiality or anonymity with the institutional obligation to respond in some format to eliminate, prevent, or address, OCR has said very clearly that the person who is in the best position to do that is the Title IX coordinator. And bear in mind that if campus police receive a report and they share it with Title IX with identifying information, it does not necessarily mean that a full investigation will ensue where we notify a respondent and we head toward disciplinary action. That balancing process and that complainant's request to keep their information private or confidential or anonymous will still be held with that individual in the balancing with the Title IX coordinator. And finally, the last unpacking of that question is it noted, does campus police have an obligation to violate that confidence? Police are not a resource that we hold on our campus as somebody who has the ability to hold information confidential in the same way that a health services or a counseling center may. So what does that mean on the coordination? It means if you look at the little red oval to the left, the spaces that Alison delineated as those who are truly confidential by state law, counseling, health services, clergy, and in some states, domestic violence or rape crisis counselor, hold that information unless and until there's an exception, child abuse or elder abuse reporting, a terrorist soft factor of risk of harm to self or other on an imminent basis, or the complainant consents for that information to be released. Other than that, it stays there, it's separate, it's in a bubble. Across the top are all of the other places on campus that a student or employee may be likely to report. And those are the individuals that we encourage you very strongly to identify as a responsible employee and or be clear about what their reporting obligations are if you choose not to identify them as a responsible employee when tracking the definition under Title IX. The goal is to get all information central, and we're doing that for a number of key reasons. One, the Title IX coordinator needs to be able to track and assess pattern and to follow and assess systemic issues that are happening on campus. We can't do that if we continue to allow information to remain in pockets around campus. If I have a faculty member who is harassing a number of students, and one student tells a coach, another student tells a different faculty member, and a third student tells their dean, I've got 3 pieces of information that are unconnected that I cannot act upon and would not begin to know that I had a pattern. So we're looking to bring things central, to break the culture of silence and to shift culture and climate. 2, each of those individuals I just referenced, a coach or a faculty member or a dean, may be able to offer some resources and information to that individual complainant, but certainly can't provide the full VAWA requirement of written resources, doesn't have access to the ability to all the range of interim measures, such as residence accommodations, academic accommodations, and other things. And 3, there are no procedural ability by that coach or that dean or that faculty member to actually be able to take effective action to eliminate, prevent, or address. It is our strong recommendation that there's a centralized reporting mechanism, that in that centralized reporting mechanism we are always sharing information in a seamless way between a Title IX coordinator, a dean of students, or student conduct if it involves a student matter, and campus police or safety, and then make careful decisions about whether or not we can accede to a complainant's request not to move forward, whether we choose to move forward with a full investigation geared toward disciplinary action. And in all cases, we're taking the steps to assess what we have, to ensure all of our federal compliance obligations, and to care for the welfare of that person by putting in resources and support and offering accommodations. Your core multidisciplinary team should include that group that I listed. A broader team would include your counseling, health services, on-campus advocates and counsel, and community partners that are critically important. And finally, as you're thinking about how you structure your multidisciplinary team, your Title IX team, your case management team, critically important that we delineate roles and responsibilities, we establish regular and open lines of communication, that we think carefully about separating out support and advocacy in the system of care, roles and functions, from the system of proof and investigation and adjudication to remove as much conflict of interest and confusion for the parties as possible. The rest of the things that you see on this slide, I think we've talked through in some great detail. It's pulling together for you the idea of how we can coordinate and bring information together. In terms of evaluating what we do and how we do it, we should always engage in a careful self-assessment. We recommend an annual review that includes the opportunity to tabletop incidents in advance, to tabletop incidents afterwards, to understand what we can learn from how an institution responded to a particular incident, to routinely seek feedback from the parties, from a complainant, from a respondent, from our investigators, from our panel members, to assess and understand how effective we are. And OCR is certainly looking for us to provide opportunities for student engagement. If we're looking to serve our students, hearing their perspective is a critical piece of that. And finally, a topic that is well beyond the scope of today's conversation and the time frame that we have is that as we think about coordinating internal effective practices, we also need to work with our external law enforcement partners. The best way to do this is to do this in advance with great preparation, to gather all information, to consider the intersections of state law, to consider the intersections of federal law, and as we work through that, to respect the integrity of the law enforcement process, to think about in the timing of your investigation where and when we can work together, where we have to defer. And again, happy to continue those conversations. It's a new and challenging area of how we learn to work really well with our community partners.
The next place that we're going is training and education. And to do all of this well, we require ongoing training and education. We need to integrate all of the federal and state laws, our reporting responsibilities, and our understanding of the nuances of trauma-informed practices in the context of fair and impartial processes. In the interest of time, I'm going to frame for you what is here so that you can have these materials and run through these lists. OCR and the Department of Education through the Clery side of the house gives us some direction on the training and education that is required for students, and it is listed there. We also get direction for training and education for all employees. Further, we get direction for training and education for employees with reporting responsibility, and that's separate and apart from all employees, but it is those employees who we designate with reporting responsibilities, whether they be CSAs or responsible employees. And then finally, the last section is the training and education required for implementers. And we will also provide a resource document which lists in detail the categories as outlined in the Title IX questions and answers on sexual violence. Finally, I'd like to end with your homework in this space. It is imperative that we review the applicable federal and state laws and guidance, identify who your team is, assess your policies and procedures to determine, are they clearly written, are they transparent, do they reflect to your community what will happen if they experience any one of the categories covered by Title IX or Clery VAWA. Assess your structure. Is it the most efficient structure? Do you have good reporting lines? And do you have the appropriate resources? As Leslie outlined, review prior cases and consider what are the effective trauma-informed, fair and impartial practices that are being used across the country. Engage your community, the best programs, engage students, faculty members and staff members, engage those constituencies with your leadership and with your local partners. And then finally, determine based on where you are now a plan with measurable action items that can prioritize some of these issues and take care of them one issue at a time.
As we wrap up, we've taken the opportunity to look through a number of questions. One of the questions, Gina, that speaks directly to the area that you were just discussing is what should we be doing with respect to our senior leadership and our trustees on education and prevention?
The tone at the top of any institution is critical. The training and education that is required for your campus community, as just outlined, is an imperative set of requirements that your senior leadership and your trustees not only should be aware of, but should be embracing. So it is our strong recommendation that both your senior leadership and Board of Trustees needs to understand the depth and breadth of these responsibilities as it relates to the safety of your community and care for your constituencies.
The last question that I think we have time to address before signing off is that if a student does not want to report a sexual assault to the police, does the college have an obligation to report? And I want to note that there may be state requirements. South Carolina, for example, under the I believe it's the Jessica Horton Act, has a requirement that they report sexual assaults or homicides that occur on their campus. There may also be other safety reasons of an imminent risk to safety that a school believes it's necessary to notify law enforcement. But to be very clear under Clery, that we as an institution have to inform a complainant who is an adult that it is their right to notify law enforcement or decline to notify law enforcement. And while we can encourage and seek to work with and assist a student in reporting a sexual assault or other crime of that nature to law enforcement, there is a strong provision within federal law that respects the adult complainant's agency and autonomy to choose whether or not to make that report. And again, as we close, I don't know if Gina or Alison have anything in addition that they want to say. What I hope you've heard in this conversation today is that much of what we are doing is seeking to strike a careful balance, a balance between victim agency and autonomy and the balance between eradicating sexual harassment and violence on our campuses, a balance between federal law and state law, a balance between the amount of information that we provide to individuals and how we can provide resources for them, and yet allow them to choose to interact within our process in the way that meets their needs in the best way possible.
I just was going to address a question of clarification when we were talking about emergency notification and timely warning. Emergency notification does have a broader focus beyond Clery crimes, but we're still talking about the Clery geography areas, so I think that's important to note as well. I also wanted to address that we covered a lot of material in an hour. I think at the start we didn't know how we would get through it all. So certainly if you have follow-up questions, feel free to reach out to us. We can certainly connect you with Gina and Leslie as well. They've been so kind to give us their time. So we are really grateful for their time, for taking a real focus on Clery and Title IX. But again, there's a lot to unpack here, and as I said in the beginning, they are really wonderful at unpacking it and working with campuses. So I would say please don't hesitate to reach out. I do want to point again, thank you all again for attending the webinar. I talked about the evaluation. That is going to be linked in the chat box. We really would appreciate just taking a few minutes to give your feedback. We provide these types of things every year in September at no cost, but also throughout the year. So if there's something you really want information on, it's very helpful for us for you to complete that information. But we really thank you for your time today. Do you all have anything to add? Okay.
We just thank you, and we are open as a follow-up to this to answer any questions that anyone has in this space. Thank you.